Good morning, everyone, and thank you for joining us today for the kickoff to LSTAR's webinar series. We have so many great webinars lined up for you this fall season, and we are really hoping that you take advantage and register for all these complimentary sessions we have to offer. Information on all of our webinars can be found on Matrix under News and Alerts, and also by logging into RealtorLink under the Education tab. My name is Caroline Trilla, and I'm the coordinator of education at LSTAR. Please note that this session is being recorded today, and a copy of the recording will be shared with everyone once it becomes available. The recording will also be accessible on RealtorLink under the Education tab under past webinars. To kick off our webinar series, today's topic was one of the most requested topics received from our member survey conducted in the fall of 2020 and also the spring of 2021. Today, we have Joe Hoffer, partner at Cohen Highley LLC, here to discuss navigating the legal minefield regarding income properties and residential properties. Joe will start with some basic principles about residential tenancies in Ontario and then focus specifically on recent changes to the Residential Tenancies Act. I'm pleased to say that LSTAR members will be among the first in the province to have the most up-to-date forms and materials relevant to the most recent changes to the RTA. The changes directly affect small landlord investors and LSTAR members who participate directly as small landlords or who act for small landlord investors. I also want to quickly go over the format for today's webinar. Everyone is currently muted. You do have the option to unmute yourself. However, we ask that everyone please stay muted to avoid background noise. So if you do have your mic on, please turn it off. You will have the opportunity to submit questions to today's presenter by typing your questions into the chat box. We will collect these questions and address them at the end of today's presentation. Please note that you may send in your questions at any time during the webinar. So to kick off our session today, please join me in welcoming Joe Hoffer, partner at Cohen Highley LLC. Joe?
Thank you, Caroline. And I do want to especially thank you for all the organization you did here, keeping me on track and making sure that that all the material was in everybody's folders for this presentation. I also want to thank one of your colleagues, Realtor Steve Tanton with Oliver and Associates. Steve was a very useful resource for me in helping me to try to focus this presentation to be relevant to realtors and some of the problems that you face in the course of your profession. And I'm really indebted to him. If there's something you like about this presentation, you can thank Steve. I'm responsible for the stuff you don't like. So what I'm going to do is really cover areas that really overlap between your profession and my profession, the law profession. We both provide services to a range of clients. This is about services that you provide to investor landlords, people that buy a property thinking that they want to rent it out. And in many cases for yourselves when you buy property and rent it out, just to refresh your memory on a lot of the principles that do apply. So I'll talk about some real basic principles, then we'll get into some of the basic obligations of landlords and tenants. I'll talk about rent controls, termination of tenancies, some of the really the legal landmines that await an uninformed landlord, and some of them have been hurt terribly by the impact of COVID and what's going on at the Landlord and Tenant Board. I will talk about the Landlord and Tenant Board and some of the processes there, and then talk about recent changes that were just introduced in September and that will have a direct impact on many of you who deal with small investment and large investment properties. I'm going to talk about some of the considerations for inclusion in an agreement of purchase and sale. And then I've provided some information about municipal and provincial regulation. And those of you who registered probably received a PDF of material. Don't be intimidated by all that material. I divided it into basically two components. The first is for new landlords, something that you may want to pass on to them just as part of a package, part of your service. And then material that's really dedicated more to realtors and some of the things that are more important for your own, really your own operation. So I will refer to it from time to time just to let you know that it's there. But in the index to that material, I've shown you where the page number is. That's the PDF page number. So you'll always be able to go there in a hurry if you're running the PDF as we're talking, or afterwards, just right on the slide deck. You can just make a note and what the page number is, and we'll get to it. So in terms of basic principles, there's really three that I always stress. And that is that the Residential Tenancies Act and most municipal bylaws are, when they deal with residential tenancies, it's consumer protection legislation. And so it is designed not to be what you would view as fair. It's designed to be more favorable to tenants. And of course, that's at the expense of landlords. And quite often, you know, I'll have a new client say, but that's not fair. And I'll say, the first thing you need to understand is it's not fair. It's not intended to be fair, and it won't be fair. Now, I'm talking about the legislation. What I find offensive is that when you go to the Landlord and Tenant Board, they tend to, for the most part, there's some exceptions, but they tend to overstep the bounds of unfairness against landlords even further. But you need to understand that that's a reality. The second basic principle or thing to be aware of is that Ontario has some of the strictest rent controls in North America. And that's in addition to the municipal bylaws that you're going to run into. And I'll come back to that towards the end of this presentation. But so just be aware of those strict regulations. Not just in terms of rent controls, but things like eviction notices and findings by the board where a notice hasn't been given in good faith. And again, I'll circle back to that, but the penalties are among the most severe in North America, and they've just been effective September 1st, they've been increased further. And then, you know, it is critical that landlords or realtors who find themselves being landlords make sure they understand the basic rules that apply to their landlord and tenant relationships. And that's what a lot of this presentation will focus on, not in real detail. We're here to, you know, have an overview of these things, but I direct you to the detail as we work through this. So one fundamental principle under the Act is that it applies despite any agreement. So you can say what you want in a lease, but if it's inconsistent with the Residential Tenancies Act, that provision is void. Now, in the basic lease that I've drafted for the majority of industry organizations in the province, that's London Property Management Association, Greater Toronto, Hamilton, Waterloo, we put right in the lease a clause that pets are prohibited, or we did until recently. And people would say, no, you can't do that, it's void. And there are a few clauses like that in the lease that most of these organizations use. The operators know they're void, but there are some people who actually honor their word and honor their agreements. And so the people that give me direction, which are landlords and property managers, prefer to leave it in there, knowing that it's void. You're not going to fall on your sword you're not going to, litigate the issue at the board. But so many people do honor their word, and so it's useful if that's a clause that you feel is important in your leases. Another provision, and it's the third last bullet. Another provision that is often put into a loosely drafted tenancy agreement is that the tenant will cut the grass and shovel the snow. You know, you think of a townhouse unit or a single family home, something like that. Those clauses are void. That's been a ruling of the divisional court. And so you have to do some legal gymnastics in order to enforce it. As a practical matter, most tenants will just do it because they honor their word. But if it's challenged, if the tenant says, hey, landlord, I'm not cutting the grass anymore, I'm not shoveling the walk, that's your responsibility, I know my rights, they're right if that's the task that you have assigned them, unless you enter into a separate contract with them. And that's a whole other process. But I just want you to be aware of that anything inconsistent with the RTA is void. The most important step is rental applications. I often find, especially new landlords, they're just desperate to get the place rented out, whether it's a condo or an apartment in a triplex or something. They just want somebody who they feel will be paying the mortgage payments, the taxes, and so on. And so they don't really approach the rental application stage as carefully as they should. Most of you know, once they're in there, it's very difficult to get them out. And so that's why it's the most important step in the process. Many landlords use incoming inspection forms. Again, that's what I always recommend. And it too is very important when you go in at the end of a tenancy to assess the condition of the unit. Under the recent changes to the Residential Tenancies Act, they've expanded the remedies, even against former tenants. And so it's very important that you use a proper rental application, an incoming and outgoing inspection report, and then, of course, a proper lease. I haven't included the rental application or the lease or an incoming inspection report in the material because they're all copyrighted by London Property Management Association. And then they're licensed out to the different landlord organizations who purchase the lease from LPMA. And so I haven't included it. Quite often, you'll find it if you Google it, but I highly recommend that you recommend to your new landlord clients in particular that they join in an organization like LPMA and keep informed, and that gives them access to all these forms. And it really is inexpensive, especially for small landlords. Just briefly on rent deposits and rental incentives. When I first prepared the deck, rental incentives were becoming huge in Toronto. It's now fallen off, so it's not such a big deal anymore. But I just want you to be aware that there are rules about what kind of a deposit you can collect. And really the only deposit you can collect is a last month's rent deposit. That's it. And it can't be for more than 1 month. You can collect certain key deposits, which are refundable. That's, really it's supposed to be the cost of replacing the key, and that's it. But there are rules around it. I'll just leave it at that. And typically, if you do need any advice on that, you can find that on the Landlord and Tenant Board website. With tenancy agreements, because I know many of you deal with small properties that have students in them, I often run into situations with those properties where it's a student lease, so you're leasing different rooms and they share common areas. And where the students don't know each other, I often find that the student is only responsible for their share of the rent. And that can cause real problems. I call that a several lease because that's what the Landlord and Tenant Board has called it, several liability. You run into problems there if that tenant vacates and the other tenants say, well, we're not letting you put anyone else back in there. And they have the right to prevent you from doing that. And so where you're using those kinds of leases, you think hard about it before you do it. Quite often it's a necessity because you won't get the parents on as guarantors, and it'll be harder to rent if a tenant is jointly liable, a student is jointly liable for the rent of the other students. But we have custom drafted those kinds of agreements for student operators and for small owners who have student leasing, so that they can separate the liability. Several liability would apply just to the room that they're in. So they're responsible for damage to that room, and to the rent that they have to pay, they're responsible for the rent. That makes the guarantor parents feel more comfortable, but there's still joint liability for issues like noise, damage to the common areas, and they're jointly responsible for the common areas of the apartment. So the living room, that sort of thing. So just something to think about for, again, somebody who's leasing to students. The Residential Tenancies Act now requires that you use what's called the standard lease. The standard lease is online. It's a form that was recently amended back in July. And while it says you're required to use it, there's no penalty if you don't use it. But be aware, if you don't use this provincial form and a tenant wants to break their lease with you, all they have to do is say, hey, landlord, you didn't use the standard lease, and so I want you to give me a copy. And then the tenant can refuse to sign it, and they can vacate on 60 days notice. So that's your liability. And if you don't provide it to them after a period of time, they can withhold rent until you do. So the standard lease, again, available on the Landlord and Tenant Board website. You can fill it in electronically. And I always tell landlords to be careful about who they identify as the tenant. Who is a landlord is usually pretty simple. It's the owner of the property, although quite often it can be a property management company. But who is a tenant is very important. Keep in mind, a guarantor is not a tenant. There's no point in putting them down as a tenant in a lease. The board tosses those cases out all the time. You can write their name in as a guarantor to the lease. That's not a problem. And then the other thing is that, there's a distinction between tenants and occupants. And so the tenant is the person that you have the legal contract with and that you owe all of the obligations to. Occupants have lesser rights under the Act, and it's important to distinguish between the two. The standard lease is really, really basic. It is 13 pages long, but most of it is text, and then there's another 13 pages of nothing but information for tenants. Nobody reads it. But what's important about the standard lease is it gives you the right to, for example, prohibit smoking. It makes reference to it directly. It gives you the right to specify that insurance is required from a prospective tenant, which is very important, especially for smaller landlords. So that's right in the standard lease. But then if you do have rules around it, you can add additional terms. And so the additional terms that I drafted for LPMA, I think there's about 30 clauses with a sub clauses under rules and regulations, so that by the time you lease to a tenant, they're looking at a document that's about 26 pages long. And as I said, nobody really reads it, but it gives you rights that you wouldn't otherwise have. And that's where we put in the smoking rules, prohibition on cannabis, smoking of any kind, limitations on pets. In condos, you have far greater rights to do that than you do in an apartment. The insurance provisions, what kind of insurance has to be in place, parking regulations, with parking, no RVs, no storage of boats, things like that, depending on the nature of the property. But the additional terms are extremely important. Tenants also have rights of privacy, and you need to comply with PIPEDA. And so what I often recommend for landlords, first of all, have a privacy policy. You just go to any large landlord, you'll find their privacy policy on their website, and just sort of tailor it to meet your needs. And then you need consent to the collection and use of personal information. And that is something I did provide in the material I gave you, because it's not copyrighted. It's the PIPEDA consent form at page 2 of the PDF I've given you. And I highly recommend you have the tenant sign, because it authorizes, among other things, email service of documents. And that is a form of service that is now used under the Residential Tenancies Act, including the ability to use email to serve an N4, which you never used to be able to do. But because of COVID, because everything's online, nobody can touch or see each other individually, the board made the adjustments and you can serve any document by email as long as you have the tenant's consent. Statutory obligations, these are things that are embedded in the Residential Tenancies Act. The biggest ones are landlord's responsibility to maintain and repair, which I referred to earlier. You cannot interfere with a tenant's reasonable enjoyment. You cannot interrupt vital services, which it is the landlord's obligation to supply. So if the tenant has the utilities in their name, and you get a notice from London Hydro, we're going to be shutting off their hydro because they haven't paid, and they shut it off, you don't have liability because it wasn't your obligation to supply that vital service. But if you otherwise have the obligation and you interfere, then it's a big problem for you. Rights of entry, I often run into issues there with realtors. The Act specifically recognizes that a realtor has a right of entry to show the unit to a prospective tenant. I've expanded in the additional terms the right to show to a prospective purchaser for lending purposes, that sort of thing. The other thing to keep in mind is for the realtor to go in, it's not, if the tenant is given notice of termination or the landlord's in the process of terminating the tenancy, you don't have to give 24 hours written notice on the prescribed form. You have to make a reasonable effort to notify the tenant. Now, people's idea of reasonable effort can vary. It's not knocking on the door and saying, we'd like to come in 5 minutes. But, it really was drafted in an effort to be a little more practical so that you have the opportunity to show the unit or to show the property without having to go through a 24-hour written notice period. So those are all laid out in Section 26 of the Act. And if you do those kinds of showings, I highly recommend you look at Section 26. It's laid out there, it's easy language, and you'll all recognize it. So I touched on landlord obligations. What about tenant obligations? There's one very small section in the Act that says they're responsible for ordinary cleanliness and they're not allowed to harass the landlord. But the board's version or view of ordinary cleanliness is much different than most of ours. It makes me wonder if most of the board members are slobs, but they really tolerate some pretty bad conditions before they'll declare a problem with the condition in which the unit is kept. And their view of harassment, it's gotten better over the years because of the Occupational Health and Safety Act and the provisions that deal with workplace harassment. But landlords were expected to put up with an awful lot of nonsense. And we now have a number of decisions which have curbed that considerably. But it's still a problem. If you said to a tenant the kind of things that a tenant could say to you, you as a landlord, you'd be penalized by the board for interfering. The tenant would get a rent abatement, and you'd probably be hit with an administrative fine. So I keep coming back to this. Keep in mind, it's not a fair and balanced venue. It's not a fair and balanced area to be in. But as long as you recognize that and just recognize the rules, you're going to be fine. Okay, rent controls, that's another significant aspect of our residential tenancies legislation. And just be aware that some residential tenancies are partially exempt. And I'll circle back to that shortly. Basically, it's any new unit created on or after November 15th, 2018. But if it's a new unit, for example, in the basement of a townhouse, you bought a townhouse and then you decide I'm going to create a rental unit down here, which you can almost do as of right now. That would only qualify for the exemption if it was unfinished space. If it's residential space now, it won't qualify. If you convert your garage, which is separate from the house, you've got one, say, at the end of the laneway, you convert that to a rental unit, that would be exempt if it was done after November 15th, 2018. So there's small rules, or if you added an addition to your existing structure and created a new rental unit in that addition, expanded footprint, then that would be exempt. So there's a lot of rules around the post-November, but if you fall into that category, then it's exempt from rent controls, and it may well be for many years. Don't build your business plan on it, because it can always be revoked. But the last new construction exemption was 1990. The NDP put it in, and it continued to exist until 2018, a very long time. So something to think about if you're looking at expanding the footprint of an existing building for rental purposes. You can only take one increase on the anniversary date, and you have to give written notice on the prescribed form. If you don't do that, the increase is void. However, if the tenant pays that for a year, then the notice of rent increase is deemed legal. And that just changed recently. That changed in July of this year, because prior to that, if you'd had a tenant in there for 10 years and you hadn't used the prescribed form, and the rent was challenged now, the board would roll your rent back to what it was 10 years ago and would give the tenant 12 months or more of the difference between the rent that they were paying and the rent from 10 years ago. And then you'd be reset to 10-year-old rents, and you can only increase by the guideline going forward. So that was a really important provision for landlords, and those of you who, or your clients who may not have been using the proper form, so long as they pay it for a year and don't otherwise challenge the legality of the rent, you get amnesty. It's no longer an issue. The increase is restricted to the guideline. The guideline is 1.2% in 2022. Unless you are exempt. And then be aware that there are above guideline increases in services and facilities. The above guideline increases aren't worth it for any small investor. Unless you have 20 units or more and you've done major work, it's really not worth it to go to the landlord and tenant board for an above guideline. That's what the AGI reference is in the bullet. Unless it's municipal taxes and charges, because you can do a direct pass-through of municipal taxes and charges, and but you can't if it's capital expenditures. You put a new roof on and you put new windows in a small building, costs you $500 plus to file your application, and then the maximum increase you can get is a total of 9% at 3% a year spread over 3 years. And if your capital cost was, it would have generated a 15% increase, you're not going to recover your capital costs. By the time you pay your $500 and go through the application process, it's hardly worth it. But when you get into larger properties, it starts to make sense. Services and facilities issues have been coming up a lot, where landlords have said, we're going to take this space for lockers and we're going to convert it to some other use. You've then withdrawn a service or facility from the tenant, and they're entitled to a rent reduction. So be careful when you change the terms of a tenancy agreement. In the context of this presentation, I was thinking of that garage, that detached garage that you decide, well, I'm going to convert that to a rental unit. I have a tenant in the main house. I'm going to withdraw the garage as a service or facility included in the rent. You could take a big rent reduction hit for doing that. So it's something to be aware of in the context of rent controls. Anytime you change the services or facilities that a tenant has, it has implications from a rent control perspective. There are some limited exemptions from the RTA, and I'm not going to go into them in detail. I highlighted a few just because, again, they may be relevant either to your investor clients or to properties that you own. I often run into situations where you have a recreational property, but there's a 6-month lease. And so, you know, and it's come up in Port Stanley, for example, where somebody goes into a condo because the owner has gone south for 6 months and they just want to rent it out for 6 months. And they feel that, you know, at the end of the 6 months, the owner will be able to come back in. And quite often the person who's moved in on that 6-month lease has said, no, this is my principal residence. It's a residential tenancy and I'm not leaving. And then you get into, you know, months and months of litigation. And that really creates a mess for the owner of the condo unit that wanted to get back into their unit. There are ways to draft the lease so that you can avoid that consequence. And, you know, again, we draft many of these recreational leases. We make the intention clear. We make sure we use the language from Section 5 of the Residential Tenancies Act to really help ensure that the owner of the unit can come back in at the end of that period. Any private school supplied housing, not student housing, but if it's provided by a university, college, or a private school, there are exemptions available there. There's certain conditions, but you don't typically need to worry about that. We often run into situations with small properties where the occupant is required to share a kitchen and bath facility with the landlord. And think of the situation where, you know, the parents in Toronto buy a condo unit, or, you know, like a 3-bedroom, or you know, a house or a rental property, and they put their son or daughter in there, and there's a number of roommates. Well, in that situation, because it's a member of the landlord's family, and it needs to be clear in the lease agreement that they do share a bathroom and or kitchen facility with a member of the landlord's family. Therefore, the Residential Tenancies Act doesn't apply. So if there's a falling out, you can get rid of the occupant very quickly. Live work rentals, I'm seeing more and more of them, mainly in Toronto, but I think we're seeing more of them in KW and in the London area as well. It's sort of a special zoning that seems to be popular by some municipalities, and some of those are exempt from the RTA, others apply, or the RTA applies. If the primary use of a live work rental is work, then it's exempt. If the primary use is residential and work is sort of a side thing, then it's not exempt. And the board will bend over backwards to find that the RTA applies. So again, you need very careful wording in rental documents if you don't want the RTA to apply to that live work use. And then any properties where you have either rehab or life skills, group homes, which I own one of, there are special rules that apply to exempt the tenancy from the Residential Tenancies Act. Termination of tenancies, the Act is very clear. It can only occur if it's in accordance with the RTA. I touched on frustration only to let you know that if you've got a 3-bedroom property, a 3-unit property, and one of those units is damaged by fire, but the other 2 are still okay, you don't have to demolish the property, anything like that. Even if the other 2, they have to be out for a while you do the renovations, the contract isn't frustrated. That lease continues. And so frustration is really only where the whole place goes kaboom or burns down. Otherwise, those lease contracts remain in effect. The tenant is liable to pay the rent and so on. There's a lot of sub rules to that, but I just want you to be aware that it's not really a way to terminate a tenancy unless the place burns down. You can terminate by agreement. A tenant may just leave their stuff behind. There may be conduct grounds such as non-payment of rent, and then there are non-conduct grounds such as you need it for purchaser's own use or landlord's own use. And then there's a special domestic violence provision where, let's say it's a joint tenancy, one of the partners or one of the tenants can give notice and be out in 30 days, can be out of that lease if they simply say that there's been domestic violence. They don't have to prove it. You can't ask them about it. You just need to know they can be out. And I've given you it's an N15 form, which is the form that they use. And when you read that form, you'll see all the rules around it. I just want you to be aware of it. By agreement, there is a form that the Landlord and Tenant Board has prescribed. It's called an N11. Even if a tenant gives you 30 days notice instead of the 60 days notice you're entitled to, have them sign an N11 because they haven't given you proper notice. And if they fail to move after 30 days, they can stay. The board has said it wasn't a proper notice of termination, they can stay. But if you have a signed N11 with them, knowing that you're letting them out early, then they can't stay. You can just file a motion and get your order. Abandonment, there's no abandonment unless the rent is in arrears. So even if the tenant vacates mid-month, takes all their stuff with them, if you've got last month's rent deposit, there's no rent arrears. You can't basically declare the premises abandoned. As a practical matter, go in and take it anyway, get it re-rented, but just be aware of that. There's no abandonment legally unless there are arrears. And then conduct, I touched on it a moment ago. Any kind of interference, any kind of bad behavior in theory will warrant termination. You have to go through a lengthy process, made even lengthier at the board these days. And then the domestic violence, sorry, it's 28 days, not 30, and then they're gone. Professional tenants know how to use these provisions to stay in for a long time. And that's why it's so important to go through the rental application very carefully, because they're out there and they're looking for people who aren't diligent. And I've seen some very tragic situations around that. In terms of non-conduct grounds, that's when you get into things like renovations, major renovations, and the landlord will serve the notice, and then the landlord doesn't tell the tenant about the fact that the unit is ready for the tenant to come back in. And that creates a real problem for landlords if they're found out about that. You can't even proceed with a renovation termination notice unless you will require vacant possession and you will require a building permit. So just be aware of that. If you don't and you serve the notice and you end up in a fight, you just won't get what you're looking for. You won't get vacant possession. Landlord's own use, there's a broad range. I've provided you with the forms in the added materials because those forms have all been updated as of September 1st, and you need to make sure you use the updated forms, okay? And when you go into the materials, you'll see the form. You can go to the website and get it. I've also given you a Landlord and Tenant Board backgrounder, which is at page 71 of the materials, and there you can click on the various changes, and it should take you right to the forms. You can't terminate for landlords or purchasers' own use prior to the expiry of a fixed term. So if you're 2 months into a lease and you decide to sell and the new person wants to go in, you got to wait till the end of that fixed term. Otherwise, 60 days notice is required on the prescribed form. You now, for demolition and renovations, if there's less than 5 units, you don't have to pay compensation. But if it's landlords or purchasers' own use, you now have to pay 1 month's compensation. And so you just want to make sure you've got that ticked off in the agreement of purchase and sale or an understanding as to who will pay. Under the RTA, the vendor has to pay. And so The question is, will the vendor be reimbursed for that 1 month's rent in a situation where it's the purchaser who wants to occupy for their own use? I've appended to the material at page 49, guideline 12 of the Landlord and Tenant Board guidelines. That has a complete roadmap for lawyers and for realtors or people who are just investing in small rental properties. It has a complete roadmap for how to get possession, what the rules are, what the liabilities are. And when you go on it electronically, you can click on that guideline and you can see, real life examples of what's occurred. Different cases are shown in the documents. So it's a great resource. I highly recommend it to lawyers and to realtors and to investors. If it is found that you issued a notice in bad faith, the penalties are huge. It's $50,000 for an individual, or $250,000 for a corporation. And on top of that, you'll see in this last bullet, 1 year's rent, just a lump sum of general damages, the difference between the old and new rent, all of the moving expenses, an abatement of the old rent. So that could turn out to be 2 years' rent, and then a $10,000 administrative fine. And tenants have up to 2 years to apply to the board for a finding that a notice was given in bad faith. And so that is a huge liability for people who buy and flip and serve notices of termination and get vacant possession and then re-rent or relist the unit. If you re-rent or relist within 1 year, even list the property for sale, that person can be liable for all of these penalties that I just laid out. And there's a new provision which requires a landlord, if they are applying to get vacant possession, to disclose all of the N13s and N12s that they have issued to tenants within the previous 2 years. And that, even if you own 15 properties, if it's all owned in the same corporate name, then all of the notices that you've given in those 15 properties would have to be disclosed on the tribunal form. There's also a presumption of bad faith if a landlord or a family member gives it for landlord's own use and then doesn't move in within a reasonable time. And you have to swear that you're going to stay there for 1 year, which is a real problem, especially when life happens. If a purchaser doesn't move in within a reasonable time, then again, there's liability. And I've seen cases where the vendor is held liable, even though the vendor has no control really over what the purchaser does, whether they move in or don't move in. And so we've recommended that there be a warranty of some kind that the seller will be indemnified if the seller is found liable for really the failure of the purchaser to comply with the requirement that they move in. What's a reasonable time? That's fact driven. It's subjective, and remember that there will be a tendency to go with the tenant rather than with the landlord when there's an issue about it. Just very briefly, the Landlord and Tenant Board and Small Claims Court are the main venues for resolving disputes. Who are these people? They are failed, lawyers who couldn't maintain a private practice and think they're going to get a cushy government job. They are people with political connections. Many are lawyers who come from legal clinics and they're just disposed to act in favor of tenants. Now, because of COVID, all of the hearings are electronic, and that's going to continue regardless of COVID going forward. You can ask for a special exemption from that, either for accommodation or for some other reason, but it's here to stay. The board has rules of procedure which govern how hearings are to be conducted. If you're involved at the Landlord and Tenant Board at all, make sure you know those rules, because if you don't and you don't comply with the processes, your case gets thrown out. There's also a whole set of guidelines that apply. And again, I referred you to guideline 12. Guideline 11 is also important for realtors and small investors, and I've put that in your materials. That has to do with collection of arrears. It's really part of certainly my Bible and the Bible of any of us who go to the landlord and tenant board. We make sure we know those guidelines, because those guidelines are basically how a board member is going to decide your case. And so you try to argue within the scope of those guidelines, so that you need to know that stuff. Decisions of the board can be reviewed, which goes back to the board, to another board member to review their colleague's decision. And quite often we're successful, and it's very cheap and much quicker than going to an appeal, which goes to divisional court. That's about a $40,000 pop if you go there. The problem, again, especially for small landlords with professional tenants, is you get your eviction order. All the tenant has to do is file an appeal in divisional court for less than $200, and that eviction order is stayed. So they continue living rent-free. And one of the things we often have to do as lawyers is we go to divisional court and ask that that appeal be dismissed because it's manifestly without merit. They're just playing the string. And even that is a $3,500 to $4,000 pop, but it stops the bleeding. And that's your goal when you have a professional tenant in there, stop the bleeding. I've seen landlords pay the tenants to leave just so that they can get the unit back and not incur the ongoing costs and ongoing rental loss. It's just disgusting how that's set up. In terms of recent changes to the Act, you can now collect utility arrears from tenants. You can collect not property, you could always collect property damage, but now if they cause you economic loss, for example, the fire department comes because of a false alarm, you can collect the $500 charge or whatever they charge you. It's really the ability to cover monetary damages that you suffer as a result of tenant conduct, including rental loss. A tenant moves out because they can't stand the way the other tenant is acting. And those are all claims you can now make that you couldn't make before September 1st. For arrears, a tenant who vacates after September 1st, you can go after them even though they're not in possession, which is again a new remedy, but you have to file within 1 year. If you don't, you're going to lose the ability to recover those arrears from that tenant. I always recommend you try to serve your arrears application while they're still in possession, but sometimes they skip. You just don't know. Just make sure you file within 1 year, or else you're going to lose your ability forever to collect that. Small claims court will no longer have jurisdiction to deal with those situations. And so just be aware of that. Anything that's pending, small claims court can still deal with, but the rules have changed around recovery of arrears from a former tenant. And there are service changes as well. It's very difficult to serve somebody who skipped. And there are a lot of rule changes around how you serve former tenants. I've given you those rules at page 64 of the materials I gave you. In theory, you can serve by email. You can still serve by mail if you know where they're living, but you have to prove these things. And there are a lot of timing rules around it. It's self-serving, but I highly recommend, if you don't know what you're doing, just have a paralegal help you. Okay. The agreement of purchase and sale, I have given you in the materials at page 80 a list of agreement of purchase or additional clauses that you may wish to include in your agreement of purchase and sale. Some of those clauses depend on how big the property is, how many units, and so on. A list of deliverables that you'd want to see in an agreement of purchase and sale coming to the purchaser. If it's purchaser's own use, you'd want a warranty that survived closing to indemnify the vendor if the purchase doesn't move in within a reasonable time. Notices or just something to provide for payment of tenant compensation, that 1 month payment that you have to make. And typically you want the leases, tenant files, some sort of warranty regarding the legality of rent charged, and then whether or not the new owner takes over any outstanding rent arrears. And we're seeing many situations where people, the rent hasn't been paid for many months, the tenant is still in there, the property gets sold. Who gets to collect the arrears? That all needs to be dealt with, or should be dealt with, in the agreement of purchase and sale. Otherwise, the purchaser can only collect the arrears that accrue from the day of closing forward. And so you really want to be in a position to collect those old outstanding arrears and continue the application against the tenant who is in default. Municipal regulation, again, very quickly, on top of the Residential Tenancies Act, you've got the Property Standards Bylaw. In London, that has recently been changed, and they have introduced a whole new set of fees and charges, which are fines for any breaches of the Property Standards Bylaw. I've given you just the list of fines at page 74 and a few pages that follow, about 6 pages there. It's $400 for failing to repair properly after you were told to repair. When you look through that list, you're just going to shake your head. It's so subjective, and yet every one of those items is a $400 fine, and it will run up very, very quickly. A property standards inspector can go through that property on any given day, and I'll suggest to you that they can find 10 violations when you have 6 pages of violations that are laid out in that bylaw, and that's $4,000 of fines. So be aware of it. If you get a letter from the municipality saying that there are some deficiencies, make sure they're fixed and fixed right. Otherwise, you have some real financial headaches. And I've included that with the landlord package, because that's what your clients and you should be aware of when you're operating these properties. There's no real right of appeal from the Property Standards Bylaw that's just been enacted in London. On top of that, you have landlord licensing. Most properties by now should be licensed if they're the small rental properties that are subject to the licensing regime. If they're not, and the purchaser has to, or the vendor has to show that they'll qualify for licensing, basically you have to go back to the 1970s and show that the additional unit or units were in there from that time forward. Otherwise, you just can't do it. And quite often a purchaser and vendor will just say, well, never mind, we just hope they won't catch us. But that's another area of regulation. And then the fees and charges bylaw, which I have provided you with. The key Planning Act considerations, I'm going to leave to the very end shortly, but remember the fire code applies, building code, you've got the Electrical Safety Authority and the TSSA. All of these things come in to regulate multi-res and rental properties. The interesting one, I think, for realtors and investors, at least in London, is going to be, and it is in other municipalities, they've all amended their bylaws to deal with additional residential units. In some municipalities, you can even convert the area above the garage, believe it or not, to an apartment. Go straight up. Again, you're going to have to comply with the other regulatory provisions, but you can add additional rental units as of right. Again, there's going to have to be compliance with all, fire and building code, but under the planning legislation and the planning bylaws, they are providing for that in all municipalities. And so what I've done is, in the material, I've given you the additional units report to the City of London and some of the related draft bylaws, so that if you're a real keener, you've got a good history of the rationale for it. And that's really what's going to inform you if you're going to advise someone, or if you yourself are going to add additional rental units. You can show how you comply with the intent of those provisions. It's all written out in narrative form, so it's very easy to use. And that's it. I did have to hurry because we only have an hour for this presentation, but I hope I've been able to cover a lot of things. You do have all the additional material, and you do have the the PowerPoint. If there are some questions, Caroline, I'm happy to try to answer a few in the time we have, if we have time.
Yes, thanks so much, Joe. And we definitely do have some time. It was such a informative session, and we do have some questions in the chat box. So I'm just going to go from the top down. So the first one, the question was, can you pass on condo fee increases?
The answer is no. The only way that occurs is in larger buildings in the context of a capital expenditure application, where you own a large number of those condo units, then you would apply almost like an apartment owner would apply, but they're very complicated applications. But a simple increase you cannot pass on. If it's a municipal tax or charge increase, you could, but not for just condo fees. And that's where a lot of condo owners get burned. They start with a low rent, and then, you know, in a new building, and then the budget goes way up, and no longer will the rent cover the cost of operating that unit, and it's just misery for them because they're paying out of their own pocket.
Wonderful. Thank you so much, Joe. Another question we have is, if the tenant was not paying taxes initially, can you ask them to pay later?
Well, they're always paying taxes initially. There's no separate breakout for a tenant other than in the context of a mobile home park or a land lease community. You cannot separate in an apartment or any other venue. You can't separate the property taxes from the rent. They're assumed to be built into the rent. And as I said, if they go up substantially in a given year, you can pass that increase on through an above guideline rent increase, but that's it.
Wonderful, thank you. And there's a follow-up question with that. I'm sorry about the wording. You said something about a municipal tax pass-through. Can you give an example?
I just did.
Okay.
I'll tell you the other place, and we're seeing it in Hamilton right now, is they want to introduce licensing, and the licensing charges between ESA, city inspections, basic license fee, and so on. And it's variable depending on the size, the number of units. It's all restricted to converted dwellings, so 4 units or less, but it's on average $2,000 a property. And so if you've got, you know, 1 tenant in that property, or even 2, that's over $100 a month rent increase, and you can pass that through. And we did that in Waterloo, and it worked out to a 6% increase, and was just a huge hit to the tenants. And yet when we made those arguments to council, they said, oh no, that won't happen. Well, it did.
Okay, next question is, what if both the tenant and the landlord agree to sign a brand new lease agreement that is above the allowed rent increase?
It's void. At least the rent is void. You can sign the new agreement, and but the amount of rent, the increase there, is void. It's as simple as that. You won't get around the act by doing that. Sometimes you'll have a rent in, let's say, John Doe's name, and you terminate that tenancy and enter into a tenancy with Jane Doe, where John Doe is the occupant. You might pull it off there, but I'll suggest to you that if that went to the board would say, they were both in there before, you've done this, it's just a sham. And there is a special provision of the act that allows them to disregard the outward form of written agreements, and they'll do it in that situation, in my view.
Wonderful, thank you, Joe. So this question was with regards to your section covering non-conduct grounds for termination. Yep. What about tenants without leases or assumed tenants who have never had a lease?
Then what the Residential Tenancies Act says is they have a tenancy agreement. And a tenancy agreement is defined as an oral or implied agreement, or it can be written. But a verbal agreement, that's a tenancy agreement for the purposes of the Act. And the terms of that tenancy are basically the terms of the Residential Tenancies Act and anything unique that you may have done. So if you don't have a lease, but they've got a garage, that garage is included as part of the tenancy.
Wonderful, thank you so much. Our next question is with regards to your slide on bad faith issuance of notices. What is the amount of renovation required for termination of tenancy?
It's an amount where you need vacant possession. The tenant can't keep living in there while you're doing the work, and you need a building permit. So typically, you're going to need a building permit if you're redoing vital services, taking out walls, things like that. And you can't have the tenant in there if there's no vital services. So you would meet that requirement. But if it's possible you need a building permit, but you don't need vacant possession, which can often happen, then you can't, well, you can serve the notice, but it won't be valid. It'll be void.
Wonderful. Thank you so much. Next question is, great information, Joe. Thank you very much for sharing. Do you know what the time backlog is for a hearing with the TBA?
If it is an eviction hearing, I think you're looking at least 4 or 5 months. If it's a tenant application, maybe 1 or 2 months. And either of those can be dragged out by somebody who knows the system.
Wonderful, thank you. Next question is, are Airbnbs considered expeditions? I don't know if that's
They may have
typo.
meant exempt, but Airbnbs they don't fall under the RTA unless you rent out for 6 months or something like that. Then you're going to have problems. But in many municipalities, Airbnb is prohibited unless it's within certain areas or they're licensed, and all these other rules apply. But they are clearly exempt from the Residential Tenancies Act.
Wonderful, thank you so much. Next question is, what happens in a scenario where a landlord is evicting a tenant due to the unit not being a licensed rental unit? Is the tenant allowed to stay?
That's a very good question. Legally, they are committing an illegal act, they along with the landlord. I personally have never seen a tenant be evicted on that ground. So, my answer to that question would be, legally, they can still stay there. You wouldn't be able to use that as a basis for securing an eviction. And what the board would say is the Residential Tenancies Act applies. It's superior legislation to a municipal bylaw. And so it's not going to allow for an eviction here. We just apply the RTA, and we're not kicking them out.
Wonderful, thank you so much. Last question in the chat box. We have infill rezoning. Are the granny suites part of this new provincial regulations? Can they be rented as a separate unit?
Yes and yes. And I've given you a lot of material at the back of the additional material that will show you how that so-called granny suite, it's actually additional units, legislation is being implemented, or requirements and legislation under the Planning Act is being implemented in the City of London. And you can go to other municipalities and you'll probably see very similar staff reports and draft bylaws, or now enacted bylaws.
Okay, I don't see any more questions in the chat box. I just want to let everybody know we do have until 12:30 today for questions set aside for Joe to address. So if you have any more questions, please feel free to put them in the chat box. I'll give a few seconds for those who are typing out their questions. Okay, I don't see anything else in the chat box.
Okay.
So I'm just going to turn my camera on here so you can all see me. There we go. Okay. So in your chat box, I did put a link in there for you to provide us with some feedback on today's session. So I just want to say thank you to Joe, and thank you to everyone for attending today's webinar. If you have any further questions about today's session, please send an email to learning@lstar.ca. You will find a link to a short survey on today's presentation in the chat box. Please take a moment to provide us with some feedback on the session. This will assist us in determining its success and where we need to improve on. Just a friendly reminder, I just want to let everybody know our next webinar In our fall series is scheduled for September 28th at 11 a.m. for 1 hour, which will focus on how to understand real estate measurements and why they are important, presented by a representative from iGuide. Registration information can be found on Matrix under News and Alerts, and also on RealtorLink under the Education tab. So on behalf of LSTAR and on behalf of our presenter today, Joe Hoffer, thank you for joining us today, and have a great rest of your day.
You're welcome. Thanks, everyone. Bye-bye.
Thanks so much, everyone. Enjoy the rest of your day.